go on the record. Good afternoon, everyone. This is the time and place notice for hearing in the matter of Rocky Mountain Power's petition for declaratory ruling regarding Kennecott Utah Copper LLC's 2015 EBA recovery charges. That's Commission Docket number 1703554. My name is Michael Hammer. I am the Commission's designated presiding officer for this docket. Let's go ahead and take appearances, please.
Good afternoon, Yvonne Hogle on behalf of Rocky Mountain Power. With me here today is Jana Saba, who is the manager of the Utah Regulatory Affairs, and also Mark Taranjo sitting in the audience, who is our Director of Commercial Services. Thank you.
Thank you.
Patricia E. Schmid for the Division of Public Utilities. I'm with the Attorney General's Office. With me at council table is Charles E. Peterson, the division's witness.
All right, and there being no other parties present, let's go ahead and begin with Rocky Mountain Power. Are you prepared to offer testimony in support of this stipulation this afternoon?
Yes, we are.
Okay.
Rocky Mountain Power calls Jana Saba.
Ms. Saba, do you swear to tell the truth?
Yes, I do.
Thank you.
Can you please state your name and position for the record?
My name is Jana Saba. It's Janasaba. I am the manager of Utah Regulatory Affairs for Rocky Mountain Power.
And are you familiar with the company's request for agency action and petition for declaratory ruling filed with this commission October 2017?
Yes, I am.
And so you're familiar with the dispute that led to the October 2017 filing?
Yes, I am.
And you have been involved in the discussions that were held among the parties subsequent to the October 2017 filing?
Yes, I was.
So you're familiar with the settlement stipulation that culminated from those discussions?
Yes.
And you have a summary in support of that stipulation that you would like to give today?
Yes, I do.
Please proceed.
Good afternoon. On October 5th, 2017, the company filed a request for agency action and petition for declaratory ruling, seeking a ruling from the Commission for Kennecott Utah Copper to pay certain charges associated with the 2015 deferral of the Energy Balancing Account, or EBA. Over the next several months, the parties held settlement discussion to try to resolve the matter informally. And based on those discussions, the company, Kennecott, and the Division of Public Utilities agreed to the terms and conditions set forth in the stipulation that was filed February 6, 2018. I would also like to note that although the Office of Consumer Services did not sign the stipulation, they also indicated that they do not oppose it. The overall terms of this settlement are as follows. Kennecott will pay to the company $114,296.36 upon the approval of this stipulation. The remaining balance of $147,930 will be included as part of the company's 2018 EBA filing to be collected from Rocky Mountain Power's other EBA customers, which will be filed tomorrow, March 15th. The parties agreed that the stipulation is in the public interest. I was involved in the settlement discussions, and I believe the stipulation is in the public interest for the following reasons. First, it resolves a dispute and allows the parties to use their time and resources for other matters. The resources necessary to continue to litigate this matter may have already surpassed the disputed amounts in this case. Second, it offers a reasonable resolution of the responsibility for prudently incurred costs. The settlement essentially splits the costs between Kennecott and the company's other EBA customers. And last, it resolves the case through settlement, which is consistent with the Commission's laws, which encourage informal resolution of disputes. The company appreciates and would like to thank the parties for working together to reach this agreement. This stipulation represents good faith efforts in resolving the dispute between the company and Kennecott that has been going on since January of 2017, and I respectfully recommend that the Commission approve it as filed.
Thank you. The witness is available for questions.
Ms. Schmidt?
No questions?
All right, thank you. Ms. Hogle, any other witnesses?
She's the only witness for now unless there are questions that she cannot answer, thus Mr. Taranjo's being here. Thank you.
All right, thank you. Ms. Schmidt.
The division would like to call Mr. Charles E. Peterson as its witness. Could Mr. Peterson please be sworn?
Mr. Peterson, do you swear to tell the truth?
Yes.
Thank you.
Please state your name, title, employer, and business address for the record.
Yes, my name is Charles E. Peterson. I'm a utility technical consultant with the Division of Public Utilities. And my address is 160 East, 300 South, Salt Lake City, Utah, 4th floor.
Thank you. In connection with your employment by the division, have you participated on behalf of the division in this docket?
Yes.
Are you familiar with the terms of the settlement agreement that is presented to the commission?
Yes.
Do you have any comments that you would like to make?
Just very briefly, the division did participate. We think of ourselves in this case as being a facilitator more than a party in this dispute between Kennecott and the company. We participated, we meaning the division, participated in the settlement discussion that is referenced in the stipulation. And the division is familiar with the terms of the settlement and agrees that all things considered, that is just and reasonable and in the public interest. That concludes my summary.
Thank you. Mr. Peterson is now available for questions.
Ms. Hogel?
No questions.
Mr. Peterson, is it the division's position that the primary let me rephrase. From the perspective of customers other than Kennecott, what is the benefit that those customers can expect to derive from this settlement?
The primary benefit is the resolution of a dispute that could have had adverse effects on the customers. The primary reason for the customers paying additional funds is that as a result of the settlement, what had occurred originally was the company had not included the Kennecott in the 2016 EBA because of the contract. The settlement includes Kennecott's as being should have been a participant in the EBA. Consequently, customers were overcompensated in the refund that was made, and given the symmetry that the division believes is appropriate in this case, that is, if Kennecott were to be charged for EBA amounts in 2015, it should have participated in the refund up through the end of November 2016 when its new contract went into effect, and that is that resulted in the ratepayers being on the hook, so to speak, in 2018 for some additional EBA funding.
Thank you, that's helpful. Is there anything else?
No, that is it, other than given that there are no disputes or challenges to the parties' settlement agreement, perhaps it would be reasonable to request a bench order. Thank you.
I can see if I can wrangle a quorum of commissioners. I didn't expect to request for a bench ruling, but I can see what I can do. So we'll stand in recess for 10 minutes, and I'll see if I can gather them up. Thank you.
Thank you.
Let's go back on the record, please. Thank you, everyone, for coming in this afternoon. Based on the Commission's review of the stipulation and the testimony presented at hearing today, the PSC finds the stipulation is just and reasonable in result, and therefore approves it. This bench order has been confirmed by a quorum of commissioners and will be memorialized by written order. Is there anything else?
Yes, one more question, clarification. Does that also mean that the commission, at the party's request, will dismiss with prejudice the company's petition for a declaratory ruling?
If the company so moves at this time, it will be granted.
Thank you.
Thank you. We're adjourned. Thanks, everyone.